Okay, good morning, everybody. I think we'll make a start. Thank you very much for joining us. We are both delighted to be speaking to you today. At the end of our presentations, we will answer questions if we've got time. If you have questions, could you please put them in the Q&A box at the bottom of the screen? And anything that we can't answer live, we will be very happy to get back to you individually and answer those questions. I'm delighted to introduce Davinia Riley. She's recently joined us from a large Midlands set. She's an established expert in family law. She's over 20 years cool. She's ranked leading junior in matrimonial finance. That extends to Schedule 1 to LATA, and as she told me, a bit of a side dish in probate as well. She's also a qualified arbitrator. So you are in very good hands, and I will hand you over to her now.
Thank you, Esther. Well, good morning, everybody, and thank you again for joining this webinar. Now, as you can see, my title may be a bit more exciting than the content. It's Privilege Stolen or Accidentally Found When Curiosity Kills the Case. Now, this is ultimately based on those times when you get a client in your office and during financial remedy proceedings, and they say, I've just found this document. Either it be a bank statement or something that you probably know is quite privileged, but something in which they think is going to actually kill the other side's case because they found this smoking gun. Now, if that were back in the 1990s, in the days of the Spice Girls and good old Noel Edmonds, you could probably use that, and the authority for that principle was Hildebrand and Hildebrand. So the facts of that case were quite interesting. Hildebrand and Hildebrand was a case of what I call the ninja husband. The parties were married for some 20 years, and the husband was a former lawyer and merchant banker. And he was seeking a massive capital payout from his wife, who was worth at the time about £5 to £7 million more than him. Instead of waiting for standard disclosure, which they standard discovery, which they did previously in 1990s, the husband decided to take matters into his own hands and help himself. So what he did was surreptitiously, first of all, photocopy all of the wife's files that were in the matrimonial home, and then when she moved into another property, he actually broke into that property and took a box of documents, obviously belonging to the wife. The wife actually caught him red-handed in the property, and he didn't have any excuse. He confessed that he was getting documents, and ultimately he said he will be using those documents in court, which he did do. It came a bit of a spat in court as to what he said and what she stole, and the wife issued a questionnaire demanding his illicit copies that he'd taken from the properties that she owned. The husband refused to give back those properties, arguing that he needed them for an element of surprise, and what he wanted to do was take the wife by surprise in cross-examination in the trial, so that he could ultimately prove to the court that she was lying and hadn't really been as upfront as she might have been with her disclosure. He served the wife with 51 oppressive interrogatories. Now, interrogatories is not something that we deal with nowadays, but again, back in the 1990s, these interrogatories were formal written questions which were served after pleadings and answered on oath. They were designed to narrow issues before trial, but he served 51 of these really detailed and oppressive, the court said, interrogatories. The outcome of the case was that the husband was ordered to disclose all of the illicitly obtained material. He said the element of surprise that the husband wanted to catch the wife out on was actually gone, because the wife knew, by virtue of her catching him in the act of stealing the documents, she wasn't going to be surprised anymore that he had those documents. The court ruled that it was an abuse of process to raise these interrogatories, and ultimately the court said he couldn't do that. However, what he could do was still use the documents that he'd obtained to cross-examine the wife on in court, which is again something that we wouldn't do nowadays. The core principles that were derided from that case in Hildebrand was that there was a duty of full and candid disclosure. The court wanted disclosure of all documents obtained, whether surreptitiously or not, and the court expressly denied and rejected the element of surprise. The court held that once the other party knew that documents had been taken, clearly there was no longer a surprise in any event. The only sanction that the husband had in that case was that he was unable to raise the interrogatory, so ultimately he couldn't raise a questionnaire. But again, as I say, interestingly, he was still allowed to keep the documents and cross-examine the wife on the same. Then comes the case of Immerman and Shenguis in 2010. Again, a case which we're probably all familiar with, particularly when people ask about the Immerman type documents. Now, Immerman was the landmark ruling on confidentiality. Prior to that, lawyers were relying on the Hildebrand principles. Sitting in the Court of Appeal on the Immerman case were some hard-hitting judges. So we had Lord Justice Moses, Lord Justice Mumby, and Lord Neuberger. The facts of that case, again, were quite interesting. We had Elizabeth, the wife, Vivian, the husband, and Elizabeth's big brothers who were simply just looking out for their sister, but did it in a roundabout way, which ultimately killed her case. The parties were married, long marriage. The husband worked in the same building as his brothers-in-law. So he worked in the same building as Elizabeth's brothers. And what was interesting about that is that the brothers in the building actually also owned the data and the means for the internet, and they could get into the data servers for all the offices within that building, an office which the husband ultimately had. When Elizabeth and Vivian were going through divorce proceedings, the big brothers took it upon themselves to actually go through all of the data that were on the servers which related to the husband. They did this because they said he told them prior that they'd never be able to find any money of his because it was all well hidden. So there was a bit of a self-help heist in that case. The shared server was used. The brothers took information from that server. They downloaded 250,000 to 2.5 million documents. Now, you wouldn't like to be the lawyer on the other side going through all of that. That would literally fill a whole warehouse. What they then did was pass that information on to their own lawyers, who sifted through the documents and ultimately got about 11 lever arch folders of documents which they said were pertinent to the financial remedy proceedings that Elizabeth and Vivian were going to be involved in. Obviously, Vivian, the husband, was incandescent with rage. How dare they break into his office? How dare they use the data that he was using? Because all of his data was ultimately protected by a password. And so this represented a massive breach of data protection rules. However, going back to the Hildebrand case, the lawyers in Immerman and Shenguis, they felt that they could use documents, and they felt that Hildebrand was a precedent for using documents, even if they were surreptitiously obtained. The wife, however, again argued that there was an agreement prior to that everybody was, so whether you're a husband and a wife, the wife's argument was any documents that belonged to the husband also belonged to the wife. And there was essentially a community of interest. They tried to argue that they were as one, and again, as the Spice Girls said, two become one when it came to the documents within a marriage. However, the Court of Appeal held that no, that is not the case. For the wife to argue that the husband and wife were one unit was a fiction. They said that the parties are individuals and separate finances and separate private life is incumbent on them. The court asked itself that if the wife, for example, had left her diary in the bedroom unopened, was it a right of the husband then to go in and look at that diary because they were simply husband and wife? The court held, well, of course not. The wife would have an entitlement to privacy of her own documents. And they held that the husband's documents were entirely his and were private and confidential. The husband had a reasonable expectation for privacy, and just because the brothers owned the server, it didn't mean that they could or should go snooping. So there were three rules that were derived from the case of Immerman. There was no right to self-help. There was no general entitlement to take any documents. Confidentiality is obviously king, and illegality is never justified. Encouraging clients to take documents, which had been the previous practice up until Immerman, simply had to stop. So Hildebrand was no longer good law, and the Lord Justices in the Court of Appeal said, to be honest, for the last 20 years, all of the lawyers had been doing everything wrong. They shouldn't be encouraging their clients to get documents that didn't belong to their client, and if they did, there were new rules and procedures that ought to take place. Now, this could be a massive problem for solicitors. Why would it be a solicitor problem? Well, going back to Hildebrand and Immerman, because the lawyers in that case were aware, fully aware, that their clients had taken ultimately documents that didn't belong to their client, they could be in breach of several tortious claims. And that was borne out in the case of White and Withers, which was a case of the famous cook, I think his name was Pierre White, and his wife were separated, Marco Pierre White, and he sued the law firm Withers LLP. He sued them because they were the wife's solicitors, and they had actually encouraged, he said, the wife to take documents from the property that belonged to him. He sued the solicitors for a breach of confidence and misuse of private information, and he also sued them for wrongful interference of property and trespass to goods. So as a solicitor, if you were to encourage your clients to take documents, you also would be at risk yourself. You could probably end up with being sued. You would obviously risk removal from the case, and there will be serious cost sanctions, let alone the sanctions to your own reputation. The court then set out a court-approved route when you want to find out what another party has got without going down the surreptitious route. You can ask the court for a search order, preservation and inspection orders, and freezing injunctions. Now, search orders are the nuclear route, in all honesty, because a search order requires an application to be made under the Civil Procedure Act of 1997, Section 1. And search order is a court-controlled alternative to self-help. What it does is allows entry into any property to preserve evidence that's at real risk of destruction or concealment. The order is executed under very strict safeguarding, including a supervising solicitor to protect privilege and prevent overreaching. So normally what would happen in reality is you would go to court and you would ask the court to grant you a search order. You would then appoint an independent solicitor who would go along to the property, and whilst there, there will be other people who will be able to search the premises of the other party, and they can take documents from that property, and then the independent solicitor will then decide whether or not those documents can be used in evidence. There's also a preservation of documents or data order that can be ordered under Part 22A of the Family Procedure Rules. Now, a preservation order prevents relevant documents or property from being destroyed, altered, or removed. It's often more proportionate than a full-blown search order, because you can imagine with a full-blown search order, not only do you have to make the application, but you also then have to instruct independent solicitors to go through any documentation that may or may not be relevant. And if it was anything like the Immerman case, although one would hope that there wouldn't be up to 250,000 or 2.5 million documents, obviously somebody needs to spend the time to go through all of that. So search orders are pretty expensive and generally used for those cases where there are multi-million pounds involved. You can also ask for forensic imaging of electronic devices. Again, this can be found under FPR 20.2a, and the court can order inspection of property, which includes laptops, computers, phones, or even data servers, and an independent expert may copy and review material, but again, that would be under controlled conditions. This is particularly appropriate when digital concealment is suspected, but privilege must be protected. There is also the ability for the court to authorise entry into premises, not unsimilar to the search order, but the power supports preservation or inspection orders. It permits court authorised entry to land or buildings in the possession of a party. It ensures that evidence can be securely or secured lawfully rather than accessed by a spouse acting independently. But again, it must be tightly framed and proportionate. You just can't go anywhere. You have to have a really good excuse, a reason for doing that. When you do suspect, or if you do suspect that the other side is dissipating assets, you can also seek a freezing injunction. Now, again, the freezing injunction prevents a party from dissipating or moving assets pending resolution of financial remedy proceedings. It doesn't determine any ownership, it simply preserves the status quo. But the applicant must show an appropriately strong case and a real risk of unjustified dissipation before the court can even make that injunction. Again, it's particularly useful where there's evidence of an asset flight or restructuring or sudden transfers of property. You can ask for an order for information about assets, and the court can direct information about the location or nature of relevant property or assets. And this is especially useful where assets are suspected to be held offshore or through corporate structures. It complements freezing orders and prevents parties from hiding behind opacity. You can also, if required, order funds to be secured into court. So where there's a dispute about specific entitlement to a fund, the court can order that it be paid into court or otherwise secured. And this ensures that any money is not spent or transferred before determination, and it's designed to be a protective rather than a punitive order. You can also seek an order requiring accounts to be prepared. So where there is a dispute, it's helpful where there's a complexity of issues. So for example, in business cases, trusts or alleged diversion of funds, this is a good order to seek if you want an account, because it forces transparency and disclosure rather than opportunistic document grabbing. As I said, the detailed procedure can be found in Practice Direction 20A. Supervising solicitor can be appointed, there will be controlled access. The court will overlook the procedure that you're going to do, and there is a protection of privilege from the other party. Applying for an interim remedy is a Part 18 application, and you identify the remedy that you want, again under Part 20.2 of the Family Procedure Rules. You issue your Part 18 application, file proper evidence. Now, the evidence needs to be very robust, particularly if you're seeking one of the more draconian orders, such as a search or freezing order. You need to set out the factual background, what the risk is, for example, of dissipation of assets, why the remedy is appropriate, and if you're asking for it on a without notice basis, you have to be clear as to why it's without notice and not giving notice to the other party. Now, that may easily be remedied by stating, well, previously, if the husband or the wife, whoever is the respondent to the application, if they've done something previously which raises suspicions, those suspicions need to be set out within your evidence so that you can persuade the court to grant you your order. You also have to ask your client to give an undertaking in damages. So for those of you who practice in civil procedure or are aware of civil procedure, it's the American cyanamide injunction case. So you have to give an undertaking that damages would be suitable for a remedy. You have to give an undertaking to issue proceedings if you haven't already done so, and an undertaking to serve any material that you do obtain promptly. You also have to give an undertaking to preserve privilege. Now, modern practice and safeguarding. I won't go into any detail of the cases, but the particular case of UL and BK freezing orders, that sets out definitively what you need to do if you want to seek a freezing order. The case of TBD, Owen and Holland and Ahmed was a case in the civil courts, but that demonstrates that you can get what we call imaging orders. So orders to get an image of someone's computer. For example, you don't need to remove the whole computer itself, but you can get an order just to download any data that can be found on the computer itself. And that was applied in Akhmedova and Akhmedev in the family courts in 2020. I understand that some of the remedies that I've explained could be seen as the nuclear option. When raids are simply too much, what you must do is, if you do get a client who gives you these documents that they've obtained, you need to preserve those documents. You should or could get independent inspections if you wanted to. You could ask for an independent solicitor to hold devices, and you can even ask for third-party disclosure. I think in all cases, you've got to think practically and think of proportionality. Best practice is if you do get the simple document that your client comes in and stating that, oh, it was just left on the kitchen table, what you need to do is don't read it any further. Don't copy it, don't look at it, seal that document, return it to the other side, and give undertakings that you will not use that document within proceedings. The other side should then, once they've read those documents, they should in reality disclose what's relevant to the financial remedy proceedings. If they don't, and you have a client who is adamant that there is something still being withheld, you can always seek court directions. But the sealed envelope approach protects you as a solicitor. The Marco Pierre White case was a case that should be at the back of your mind, is if you do anything that isn't along the guidelines I've just read out. If there's any suspicion that you've taken any documents surreptitiously or opened any privileged documents, the other side could sue you for breach of confidence, which is not something that one would want to go through. So ultimately, you have your red flag moment. When your client said, I found these documents, what you should do is ask yourself immediately, how were they obtained? Would they be confidential or privileged? Have I seen enough to stop? And my advice to you would be just to say, if they're not in the name of your client, seal it up, send it to the other side. Don't get bogged down in anything unless and until you have further evidence to go further. So just leaving you then with the golden rules. If clients obtain documents improperly, stop, seal and return. Use the court, but protect yourself first, because as practitioners, nobody wants to go through the embarrassment, quite frankly, of being sued from the other side for not disclosing any documents when they should. So I think that's taken me to the end of my slides. Thank you very much for listening. I'm not sure if there are any questions, but a couple that have arisen before I hand over to Delphine is, what if the documents clearly prove fraud or non-disclosure? Surely the court would want to see them. Now, the proper approach would be to stop reading straight away, seal and return, and use the court's powers to deal with anything if you feel that there is a proper risk that there are non-disclosure elements to the case. And is there ever a situation where documents left in the home genuinely lose confidentiality? It's a nuanced case, but again, I would always urge on the side of caution. If, for example, the parties always have access to one another's documents, then you've got an argument there that, you know, wife used to look at husband's documents and open them and vice versa. If that is genuinely the case, then you do have the argument that these were open documents. But again, I would always just urge on the side of caution and send on any documents that you do get to the other side as soon as possible. Thank you for listening. I will now hand over to Esther for her talk on New Year, New Rules, Understanding the New Practice Direction 27A.
Thank you very much. I'm afraid I don't have any Spice Girls quotes in this presentation. New Year, New Rules, Understanding the New PD 27A. You are remembered the rules you break. Now, for some, John Wayne, Donald Trump, that might be a statement of aspiration. Imagine, though, that being said in the chilling tones of Mr. Justice Peel, and that may explain why so many of you have signed up today. The new PD27A comes into force next Tuesday. There are no transitional provisions. It will be effective immediately. Practice Direction 27A was last substantively updated in July of 2018, so this revision is clearly welcome and somewhat overdue. It's designed to modernise the law and embed best practice. In my view, it reflects the changes in the increased use of technology, e-bundles, electronic tablets, changes in how evidence is collected and presented. Obviously, I'm thinking about all the video footage, audio footage, photos that your clients will send you. It reflects the need for more rigorous case management, addressing the backlog of cases, and of course, the reduced sitting hours for judges moving forward. And there's an improved awareness of the needs of vulnerable parties and litigants in person in how to engage fully with proceedings. The new PD27A is nearly twice as long as its predecessor, and it has separate chapters for financial remedies as well as public and private law children. So why take this seriously? Clearly, the efficient gathering and presentation of evidence ought, in theory, to enable the issues to be identified, disputes resolved, cases disposed of in a more timely and efficient manner. If that's not enough of an incentive, then at paragraph 3.1, we are reminded that a failure to comply with any part of the practice direction will result not only in delay, but costs being ordered against the non-compliant party. And if the carrot and stick are not enough as an incentive, then unarguably adherence to the rules must be essential for there to be an equal playing field. As Mr. Justice Mostyn says, it should be understood that the deliberate flouting of orders, guidance and procedure is a form of forensic cheating and should be treated as such. So when does PD27A apply? It applies to any hearing, that's any appearance for any period of time, on or without notice, in the family court or the family division of the High Court. The application of PD27A is not waived, even where cases are urgent, although in those circumstances, certain exemptions may be granted. Now, before I get into the detail of the practice direction, there's two caveats. Firstly, I'm not going to cover every single provision. We simply don't have time for that, so please do read it in full. Secondly, pretty much every chapter within the direction is bookended by the caveats subject to any case management direction, unless otherwise directed, etc. So do bear that in mind, even if I haven't spelt that out expressly. So turning to the first new edition at chapter 4, this incorporates the guidance from 2021 in respect of e-bundles. Crucially, unless the court orders otherwise, bundles should be electronic. They should be e-bundles. Although, if the party who is tasked with preparing the bundle cannot do so, then they may file a paper bundle. There may be circumstances where an e-bundle has been produced, but there is an additional need for a paper copy, for example, to provide to the witness in the witness box, or a party who cannot access an e-bundle, in which case a paper bundle will need to be provided in addition, and that will also need to be PD27A compliant. Chapter 11 sets out the requirements of the e-bundle, and this applies to all types of proceedings in the family court, so financial remedies and public-private law children. It must be provided in a PDF format, not to exceed 350 pages. Page numbering must be computer generated, so not handwritten. Public and private law bundles will need to adopt the Bates numbering system, and I will come back to that, whereas bundles in financial remedy proceedings will continue to use Arabic numbering. The pagination of any paper copy must match that of an e-bundle. I'm smiling simply because you'll have all been in cases where that hasn't happened, and at least a third, if not more, of the hearing is taken up with everybody trying to find themselves on the same page. The index that goes towards that point, all documents in the bundle should appear in the bundle, in the index, apologies, and there ought to be hyperlinks to those, and where possible the bundle should be searchable. Any document which isn't a text document ought to be optical character recognition so that it can be searched, and please, all pages should be the right way around. The default size is 100%, and the quality, there should be resolution of no greater than 300 dpi. That allows the bundle to be effectively scrolled through and attached to one single email. Another change here, I mean, this whole chapter is new, but we'll see this repeated at a future point, which is that whilst font size remains 12 point, 1.5 or double spacing, it's now been recognised that the Arial font is generally considered to be more accessible to neurodiverse readers, and so practitioners are directed to use either Arial or Times New Roman typeface where possible. There are then some additional provisions in respect of providing a core bundle, and that can only be done with the court's permission. And in the event that a new document needs to be added after the bundle has been filed, then the court needs to be provided with the new document, a new section, and an entire revised bundle, in case, of course, the court has already started marking up the bundle it has received. Paper bundles, these are covered at chapter 12. I'll just pull out again the sort of key changes here, given that not much has changed, except for the fact that they should now be printed double-sided. So whilst there's still a limit to 350 pages, it's in fact 350 sides, and therefore a limit of 175 pages. And again, practitioners are directed to use Times New Roman or Arial font where possible. Chapter 5 of the practice direction deals with the contents of bundles. It's of general application, this chapter, to documents in, again, financial remedies or public and private law children. The general rule that was in the previous practice direction remains, which is that only documents which are relevant or necessary or will be referred to should be included. The list of documents that are not to be included in the bundle has changed, in that it now includes correspondence between solicitors, copies of emails, text messages, WhatsApp messages, or any form of social media communications, voice notes or other recordings, and photographs. These are all now prohibited. The practice direction does then go on to say, however, that it does not prevent the inclusion in the bundle of specific documents which are necessary for the court to read or will actually be referred to, which seems to be somewhat of a contradiction. It seems to me, at this stage, therefore, that the safe approach would be for permission to be sought at a hearing, or reference made to the existence of these documents in a position statement, and permission sought before they are in fact filed within a bundle. You should also note that the list of prohibited documents no longer includes medical records and police disclosure. And of course, all of these amendments, they align with the guidance, recent guidance concerning covert recordings and the use of intimate images. Chapter 6 is therefore deals only with bundles prepared in financial remedy proceedings. The format and contents of the bundle I've set out here at paragraphs 6.2 and 6.3. And as I've said, do note that Arabic numbering should continue to be used, and practitioners need to ensure that page numbers in the e-bundle match the PDF numbering. We see at paragraph 6.3 that section A of any bundle is for preliminary documents, and preliminary documents are then expanded upon here between paragraph 6.4 and 6.9. They largely reflect what we are now familiar with from the statements of efficient conduct. Whilst it says in the practice direction that each party should file their own set of preliminary documents, that provision must be, or it is subject to the requirement that documents are, however, agreed so far as possible. And it must, of course, still be the expectation that there is only one ES1 and one ES2, given that they already are formatted to accommodate dissenting views between the parties. These practice directions, which may well be filed after the bundle, include therefore the ES1, the ES2, the FM5, an up-to-date chronology, position statements, and in any hearing that is listed to last for more than 2 hours, so that would include, for example, any MPS, any last payer applications, you will need to include a witness or hearing timetable. And there are additional provisions within the practice direction as to what that timetable should look like. For example, not including more than 30 minutes for opening, and make clear that there ought not generally to be provision for evidence in chief. So you will need to bear that in mind when putting together a timetable. Paragraphs 6.9 and 6.7 remind practitioners that a preliminary document should be as short and succinct as possible, and where possible cross-reference to the bundle. There is an entire section, or a couple of paragraphs rather, in respect of position statements. Again, in my view, this is helpful. We are all too familiar with position statements ranging from anything between 2 to 20 pages. Sometimes they are nothing more than a case summary. Other times they are full-blown and previously unseen evidence. That needs to stop. Position statements are defined as any form of written submission by a party or their advocate, and this includes a skeleton argument. I draw attention to that because in public law and private law proceedings, a position statement does not include a skeleton argument, but it does in financial remedy proceedings. The 6.12 then incorporates, as I've said, several of the provisions recognisable from the Statement of Efficient Conduct. We see that there are page limits relevant to each individual type of hearing, and that those page limits include any schedules that the author may wish to include. They need to be set out in numbered paragraphs, cross-reference to the bundle, but need to be self-contained, so should not make reference to any previous position statements. Crucially, in my view, again, another bugbear of mine, position statements should not introduce any new factual allegations or evidence or include any exhibits. Now, of course, it's difficult when a client produces something last minute and wants it put before the court, but without permission to file further evidence, it is clearly wrong to bring it in effectively through the back door attached to a position statement. And that must be right, as it goes back to the principle of fairness and not ambushing the other side through procedural breaches. Finally, the position statement will need to address the parties' compliance with the duty to negotiate and their views on NCDR. And we have some further guidance as to the use of authorities, reflecting the recent practice directions on the citation of authorities. We then have, similarly, at Chapter 7, provisions in respect of public and private law children. Paragraphs 7.2 and 7.3 applying to both public and private law children. Note, therefore, that these proceedings will use the Bates numbering system. So that is where there are separate sections A, B, C, and D, and so forth, and the numbering system starts afresh at the beginning of each of those systems. I apologise for telling you something you already know. The difference between this and that for financial remedies seems to be a recognition, essentially, that proceedings within public and private law children quite often a bundle from one hearing to the next may be very similar. It may be that there's only the addition of a new social work assessment or care plan, and it avoids the need for the entire bundle to be renumbered simply to accommodate that new document. We see here at 7.3 what those bundles ought to include, and I have added in there what the page numbers are, or page limits, I should say, for individual documents as set out at paragraph 8.1. Again, there's a focus on what the preliminary documents ought to look like. Paragraphs 7.4 to 7.7 are in respect of public law children only, so not private law. And we have the definition or setting out really of what these PDs are at paragraph 7.6. Again, there is a requirement to file a hearing or witness timetable for any hearing that is likely to be evidential, contested, or a final hearing, and a reminder that any case summary or position statement will need to be prepared using a standard template provided for in the area. Paragraphs 7.8 to 7.10 do the same in respect of private law children. The difference here is, whilst in public law proceedings, there is provision for the preliminary documents to be filed separately. I'll just take you back to that slide at 7.5. You can see that each party can file their own set. At 7.9 to 7.10, these need to be agreed between the parties, and they need to be prepared by either the applicant or the next represented party. Again, FM5 needs to be included, as does any hearing or witness template for an evidential contested hearing. Paragraphs 7.11 to 7.15, they deal with the format of practice directions. This goes back to both public and private law, and again, they can be filed after the bundle itself. And similarly to the provisions in respect of financial remedies, we have here at paragraph 7.18 a definition of what a position statement should look like. And as you'll see above, a position statement in these proceedings does not include a skeleton argument. The position statements ought not to exceed 3 pages. That is specific to public and private law proceedings only, unless the case is complex and the court has directed otherwise. Who prepares the bundle? Paragraph 7.19. Again, we have provisions as to how to cite and how to refer to authorities, and a reminder to practitioners that a new position statement should be prepared for each hearing. So, moving on to who prepares the bundle. The default position remains the same. In the absence of any direction from the court, it falls to the applicant to do so. If the applicant is not represented, but the respondent is, then it falls to the respondent. In circumstances where both parties are litigants in person, so by definition, cases in which you will not be involved and therefore may not therefore have the joy of receiving a bundle prepared by HMCTS. Of course, if you are instructed at a later stage and you are sent a bundle that is not Practice Direction 27A compliant, that is why HMCTS may be directed to prepare a bundle where both parties are litigants in person and the court is satisfied that neither of them are able to prepare a bundle themselves, then HMCTS may be directed to do so, but their bundles do not need to be PD27A compliant. Chapter 13, this is a very short chapter, but it is an important one, and you'll see I have highlighted some dates here. Practitioners need to be aware that the content of a bundle needs to be agreed 7 days in advance. Bundles need to be filed and served 5 working days in advance, and preliminary documents need to be filed and served by 11 o'clock on the previous working day. Once a bundle has been filed, it cannot be amended without the court's permission. Again, this seems sensible. All too often, a judge will ask me which of the many bundles filed in rapid succession ought to take precedence. This does put a stop to that, hopefully, but it does put the onus on practitioners to get the bundle right the first time. And it seems therefore obvious that when practitioners are timetabling for the filing of evidence ahead of another hearing, then they need to ensure that sufficient time is given for the documents to come in, the contents to be agreed, and the bundle to be filed in a timely manner. Chapter 14 then deals with the filing of e-bundles. We're told what the file name needs to include, and that the default is that where a portal provision is available, the portal should be used for the bundles to be uploaded. If there is no portal provision, then bundles may be uploaded by email. Where the bundle is too large, and the previous provisions that we've looked at ought to avoid that arising, but of course it may well happen, then with the permission of the court, you can use a document upload centre, but that does need to be with the prior agreement of the court. In circumstances that I've touched on where there is both an e-bundle and a paper bundle, then that paper bundle needs to be filed in accordance with Chapter 15. I haven't set out Chapter 15 or indeed Chapter 16 in full, in part because most of you will already be familiar with the provisions, given that they predate the introduction of e-bundles. And there are, again, separate requirements in respect of whether it's before the magistrates or indeed, as per Chapter 16, whether the hearing is in the Family Division or in the RCJ. So please do look at those yourselves if that's going to apply. Practitioners should note, again, the warning at paragraph 15.1 that if a paper bundle is filed in the wrong place, then a court may treat the bundle as not having been filed at all, and it may take the steps referred to at paragraph 3.1, namely costs. Taking cases out of the list, that's at chapter 19. It remains largely the same, this procedure, as its predecessor at paragraph 11 previously. There's an important addition, though, which is that any application to adjourn, if it cannot be uploaded to the portal, then it must be both emailed to the court and a hard copy filed as soon as practicable. That is a new development from the previous provisions. I've cantered through that, looking at my watch possibly slightly faster than I expected, which means I may have at points spoken too quickly. The slides will be made available, and perhaps more helpfully, a practitioner's guide to the revised Practice Direction 27A is going to be produced. I'm not sure when or by who or in what format, but it will be disseminated, and that ought to provide some guidance, particularly in any areas that I've not been able to cover today. I'll hand you over to Davinia just to deal with any questions that may have arisen while she was speaking. I know some have come through for me, and I'll deal with those afterwards. Thank you very much. I might just work out how to stop sharing.
Thank you, Esther. Just going through some of the questions. The first one is, how would you prove that the other side solicitor has encouraged their client to obtain documents fraudulently? Now, that is going to be a really difficult thing to prove, in all honesty. So you've got to have some real strong, I would suggest, documentary evidence before you start accusing another solicitor of encouraging their client to do things fraudulently. If it's just a case of your client saying to you, well, I think that, for example, the wife's solicitor has told her to get all this information, that's not going to hold weight with the court. So you have to have some really strong evidence that there has been encouragement. I think if I link that back to the Hildebrand era, solicitors were positively encouraging their clients to do that. But since 2010, that practice has thankfully stopped. And so it's a very serious accusation to make. So you must really have some hard evidence if you want to go and pursue that route. The second question is, what should the approach be where clients send private documents by email, especially where the email itself contains a mix of wrongly obtained private information and information that we need on record? For example, the client has read the wife's diary and emails us with quotes as well as threats to the wife's safety. Well, first and foremost, safeguarding is key. But if there are private documents that have been uploaded and they're documents that aren't in relation to your own client, again, it's a case of letting the other solicitor know if the other side is represented by literally stating that confidential documents have been uploaded. If there are any documents pertaining to your specific case, so example, in relation to financial remedies, you want to add on, you want to remind the other solicitor of their duty to disclose everything within their knowledge within the proceedings. Third question is, we've recently had this issue. Client is concerned that the other side solicitor, again, may have encouraged their client, and that's a repeat of the first question. What I would say to all of you within financial remedy proceedings, I think there's an underused element of the financial remedies in part 20. So for example, you can obtain third-party disclosure orders, which can be against banks or, for example, even crypto wallets if they're based in the UK, and obviously freezing orders. And the thing to remember with these applications is when you're making them, they are cost bearing. And so obviously if the other side is proven to have hidden something, your client will be protected somewhat in getting their costs back from making that application. So I would always threaten the other side if you need to with an application to court. First of all, their client won't want to be paying any other costs. And secondly, if an order is made against their client, they're not going to look too great when it comes to the final hearing or FDR, when the court is made aware that there needed to have been additional orders for disclosure. So try and use those remedies if you can to your own advantage. Just going through to see if there was anything else. I think there was a question about crypto wallets. I'm just going to scroll. Again, cryptocurrency. So yeah, cryptocurrency, the electronic wallet doesn't have the ability to generate a bank statement. So should these be searched under order? Yes, they can be searched under order. You can get a third-party disclosure order. You can get a freezing order if you need the holder of the wallet to stop spending. So again, it's about using those remedies. Cryptocurrency is difficult, but there are experts that you can instruct to look through the crypto wallets and obtain keys if necessary. So again, try and use the remedies that's available to all of us within part 20.2. It gives you a whole list of the remedies, which I've put in my slide, and also sets out the detailed procedure, which is essentially a Part 18 application that needs to be made to court, and not forgetting, most importantly, the ability to recoup your costs if you need to make that application. I think those are all the questions for me, but if you do have any other questions, just going to give Esther some time to answer the questions that have been posed with regard to her presentation. You can always drop me an email in chambers and I'll be happy to help. So I'm just going to pass on to Esther to answer any questions she may have.
Thank you. There's been a lot of questions coming through, which is fantastic. A lot of them are sort of broadly on a similar topic. I'll sort of try and address them in, group them together where I can, and where I can't, then I will get back to you individually. I think a lot of the questions are sort of really coming to the question of what if you feel that the other side, who have either got sort of conduct of the bundle or who you're trying to agree with, are not agreeing. You don't think that they are adhering to the practice direction 27A properly. What do you do? Do you, file your own bundles after all and go your own way? I think it seems to me, I mean, the practice direction, as I said, there are at several points within the various chapters provisions for so far as practicable or can be agreed where possible or subject to case specific directions from the court. These are potentially the caveats that you may need to rely on, but it is so clear that the court is trying to reduce the amount of correspondence and sort of duplicates of different documents coming in, because that can be seen as sort of ambushing either the other side or the court. My view at the moment, having read both the revised direction and also the consultation responses that informed it, is that every effort needs to be made to avoid that situation. If documents cannot be agreed, but you are not the one with conduct of the bundle, then it may be that you need to set out at the very sort of opening paragraph of a position statement where the disagreements between the two of you, the two parties, lie in respect of the content of the bundles, and to have any documents to hand that you think ought to be included and haven't been included, so that you can present those to the court if the court says to you, well, come on, then let's see what it is that you have that isn't in the bundle. I appreciate that that is not a hugely satisfactory response and potentially doesn't take us any further forward than we are now. But it does seem to me that a lot of these difficulties which arise, as we say, it was, either from other solicitors' firms who are not as familiar with the rules as they should be. That can be dealt with, of course, with sanctions, with the threats of costs, and the court can be invited to exercise its powers in that manner. With litigants in person, it is somewhat different. That said, there are, of course, the authorities that litigants in person are not exempt, they're not held to a different standard, and that's why I think both this practice direction has been written in much simpler terms. There are far more provisions that make it accessible to litigants in person. Of course, some of the provisions require technology that they simply might not have, but there is always the provision for documents to be provided in paper copy, for example. So there is perhaps slightly less wiggle room for them in that respect, and there will be guides provided for them, but it's never going to be a perfect solution. As is my answer, therefore. One very quick question I can answer: whether the statement of issues is no longer needed in financial remedy proceedings. No, it isn't. That's where the ES1 comes in. So that's one less document to provide. And again, a lot of questions coming in, which to me are perfectly sensible, if not obvious questions, which is, given the prohibition now on including photos, WhatsApp communications, etc., what do we do about the fact that they form the bulk of our client's evidence? Again, it seems to me that there's probably going to be a bit of a teething stage with this new practice direction, whilst practitioners and the courts, in fact, work their way around it. I think what the courts don't want, again, given the limits on bundle size, is for what we often see hundreds or even dozens of pages of screenshots. It does make it very difficult, though, for parties to be able to respond if they don't know what is being said. And it may be, I think, in my view, again, that a statement will need to include a paragraph at the beginning or at the end with reference to the exhibits that a client or party wishes to rely upon, and for permission of the court to be sought for those documents to be provided, because there is that caveat at paragraph 5.2 at the end of the list of prohibited documents that said that it doesn't prohibit the inclusion of documents that are going to be necessary, and it seems to me therefore that judges will be using that to bring them back in, but perhaps it just allows an additional filter by the court, provided it's got time to do so in a hearing, to ensure that the documents that are now being or will then been adduced with permission are both appropriate, bearing in mind the rules in respect of intimate images, and are proportionate as well. I will, as I said, a lot of the other questions coming through are broadly on similar topics. So what I'll either do is email everybody back individually, or if it's of assistance, potentially put together a note. It may be that I'll wait until the practice direction becomes live next week, see what other guidance is handed down, and then put together a note at that point. So that's probably enough from me today. Thank you again for joining us, and I'll just pass you back to Davinia.
Thanks, Esther. Again, thanks all of you for giving up your time and for interacting with us. Your questions have been really useful, and hopefully you found this presentation helpful. Just to let you know that the next brunch webinar will be on Wednesday, the 25th of March. And there is a forthcoming Private Law, Children and Financial Remedies Conference, which you may also be seeing me at again, and that will be on the 23rd of April in Birmingham. There will be a registration link in the chat for you to register for that. And also keep an eye out for our financial remedies or newsletter, which hopefully will be coming out sometime in March. So without keeping you any longer, I'm sure you're all very hungry and waiting for your lunch. Thanks once again, and hopefully see you in person at some point soon. Thank you.